This is our second argument for this morning, October 4th, 2022, State of Ohio versus Elliott Kirkland, case number 19CA011485. As you can see, Judge Hensel, Judge Sutton, and I will be your panel this morning. I will be presiding. Each of you will have 15 minutes for your argument. Attorney Hannadell, you may reserve up to 5 minutes for rebuttal. I'll be keeping track of the time, so just let me know when you start how much time you'd like to reserve, if any, and I'll let you know as you get close to that time. We don't use the names of victims or children in the arguments. We ask that you refer to them in some other manner. I can assure you, Judge Hensel, Judge Sutton, and I have read the briefs, and we are prepared to proceed if you are. So before I start the clock, Attorney Hannadell, would you like to reserve some time?
Yes, 5 minutes for rebuttal, please.
All right, and I will let you know as you get close. Go ahead, sir.
Thank you. May it please the court. I'm Stephen Hannadell. I represent the appellant Elliott Kirkland. Mr. Kirkland was convicted of aggravated murder, and he ultimately was given a sentence of life without parole. And however, it didn't start out as a death penalty case, but then it became a death penalty case, which ultimately the jury ruled against the death penalty and recommended life without parole. And the way that all happened and transpired raises several issues in this case, because Mr. Kirkland was arrested on the murder charge. He was charged in Lorain Municipal Court on around August 30th at 16. He was not formally indicted in common pleas court by the grand jury until November 2nd of 16, and in that whole meantime, he's sitting in jail and the speedy trial clock is ticking. So he gets indicted in November. The speedy trial clock, which at this point is based on 90 days because he's in jail, is rapidly ticking, and given it is a murder case, it's a very sizable, complex case, as most murder cases are. And Mr. Kirkland, for whatever reason, decided to exercise his right to speedy trial, which then forced both prosecutors and the defense attorney to really have to rush and get prepared in a very short amount of time. And obviously that was an enormous gamble for Mr. Kirkland because, he was risking that his attorney wouldn't, be fully prepared to present a good defense on his behalf. However, as he did that, in the trial court was making sure that it set a trial date to be before the speedy trial deadline, the statutory speedy trial deadline. What transpired between the prosecutor and the court and the defense attorney, ultimately, as much as the prosecutor was saying that, I'm ready to go, his conversations and his statements in court, I think, speak otherwise, because he was trying to manipulate the situation to get Mr. Kirkland to eventually agree to a continuance, which he did. And then, sure enough, even though they had agreed trial dates for some time in the spring of 2017, but before that, you're talking within a month after, or roughly a month or so, after these pretrial proceedings, suddenly the state adds a death penalty specification, and there was no new charge. It's not like there's a big difference between when we talk about prosecutorial vindictiveness. There's a big difference between additional charges when new evidence comes to light, which that does happen. There was no new evidence in this case. I mean, the state knew what it had. They had a pretty good idea what happened, and they just decided to up the penalty. And that when we look at the prosecutorial vindictiveness analysis, that's a major distinction. And and also you got to look at it in context of the state waited over 2 months to indict Mr. Kirkland while he sat in jail. I mean, they brought this situation on themselves where he was forcing this high stakes maneuver to exercise speedy trial, but nonetheless, it was his right. I mean, we can have a debate as to whether that's good strategy or not, but that was his right to do. And in the constitutional case law of the U.S. Supreme Court says that a defendant cannot be punished for exercising a right that he's plainly allowed to do, and that's what Mr. Kirkland did. And for doing that, the state comes back with a death specification, and that totally altered the entire proceedings from start to finish, because death penalty proceedings are their own creature. And he had to get 2 new appointed attorneys on the case because his prior trial counsel was not death penalty certified. And so these two new attorneys had to start over. They told him to waive speedy trial because they needed a lot of time to try to prepare a good defense, to try to save his life. And, all the motions that have to be filed, voir dire is conducted differently, and voir dire is affected because death penalty trials are more likely to yield juries who are more believing that the defendant's guilty, because with the people who object to the death penalty and tend to scrutinize the state's evidence more, they get excluded. And so the entirety of the proceedings is affected. And then, even though the jury did spare his life, but at the same time, not really, because these days there's really no practical difference between a life without parole and the death penalty, especially because the death penalty in Ohio is effectively on hold. But the life without parole is considered a break instead of maybe being considered the max, because had there not been the death penalty in this case, then Mr. Kirkland would have gone before the judge as any normal sentencing, where the judge would have considered, under aggravated murder, 20, 25, 30, or life without parole. The 20, 25, or 30 to life, or life without parole. And the life without parole would have been the maximum he would have received, and the judge would have had to consider all the sentencing factors in 29, 29, 11, and 12. And it just would have been a totally different context. And so, and if the judge would have felt that he wasn't deserving of the max, then he has a chance at parole someday. But by installing the death penalty in this case, the character of the proceeding got altered entirely. And the state did so vindictively. It's not like they made a decision in the very beginning of this case to put in the death penalty, which they could have done, but they just chose not to. And they also chose to wait 2 months to indict him.
Let's go back to that time waiver, because I don't believe you've assigned as error any ineffective assistance of counsel for the original time waiver. Once he waives time, how do we deal with the fact that once time is waived, the state, if the evidence supports it, can certainly, supplement that indictment with a death spec?
Well, I don't think the time waiver really matters in this case, because if he ultimately agrees to waive time, then he can do that. But then it's the way the state responded to him, exercising speedy trial right. And then, and when you look at the proceedings in the transcript, he had to be pushed and prodded to waive time, or at least told time is what he did for a period of time. He didn't outright waive it yet, not until the death spec was added to the indictment. But you're
arguing he was coerced into waiving that time, number one. And number two, can you let me know how much time was there between the trial date, between that waiver and the trial date? Excuse me. Let me be even more specific. How much time was there between the time the death spec was added and the trial date?
Okay, the death spec was added on January 13, 2017.
Okay.
The trial was not done until 2019. Okay. However, it was in November of 16 is when he was trying to force the speedy trial.
All right.
And so so it was on November 22nd of 16 when they had court, and they finally they agreed to a temporary tolling. It was not an outright waiver, temporary tolling, to where they have a next pretrial on January 23rd, and then a final pretrial on April 3rd, and then a trial on April 18th of 17, just several months later. So he wasn't agreeing to push it out much, but as you could tell from the transcript, there was a lot of discussion, a lot of just back and forth, and he was being steadfast for a while, saying, no, I want to force my speedy trial, I want to exercise my right, and then the prosecutor kept going and going, and then the judge was, at least, I don't think the judge was in any way forcing him in one direction. The judge was just trying to make sure he was understanding what he was doing and understanding the risk involved, but even then, Mr. Kirkland indicated he did understand, and so right after we have this continuance is when the state suddenly adds the death penalty for just apparently no reason at all. There was nothing new to suddenly just prompt to add the death penalty. Nothing new that the state didn't know before, back in early, late August, early September, or even early November, when they indicted him formally for the murder charges, the murder charge, and the other charges as well. So I think there all, as much as there is a presumption against vindictiveness, the presumption can be overcome. And I think you have to look at the particulars of how the proceedings transpired, because like I said, that the state put themselves in a position by waiting 2 months while he's sitting in jail to indict him. And then, he had the right to exercise a speedy trial. And like I said, we can all debate whether that's a good idea or not, but nonetheless, it was his right. And then it's in response, and then he's pushed and prodded to at least toll the time and at least allow his attorney more time to prepare. And that was the condition, or at least the understanding he had when he agreed to that continuance. If he would have known that the state was going to use this extra time to add the death penalty to the indictment, I don't think he would have agreed to it. I don't think anybody would.
Counsel, you're at the point where you're going to be getting into your rebuttal. Do you want to continue, or?
I'll just continue for 2 more minutes, because I just want to touch on the fact that
Go ahead.
On the third assignment of error. So after the jury returned a recommendation of life without parole, the trial court judge his hands were tied by the statute to not alter that recommendation. And yet, however, if the jury came back with the death recommendation, the judge would have the discretion to lower that to a 25 to life, 30 to life, or life without parole. But yet, when the jury comes back with a life without parole, the judge was not allowed by the statute to lower that to a 25 or 30 or any sentence that would give him a chance with parole. And that's unconstitutional. There's no rational basis as to why in one situation the judge is allowed to lower the sentence to give the person a chance at parole someday, but yet when the jury quote unquote cuts him a break with a life without parole, then suddenly the judge's hands are tied. I mean, that makes no rational sense as to why in these two situations that the judge has discretion, and the other situation the judge doesn't. There's no rational basis for that. The judge is not supposed to be a rubber stamp for the General Assembly, and if that's what's supposed to be the case, you might as well just have a clerk just put stamps on pieces of paper. So the judge is the ultimate decision maker when it comes to sentencing, and he should have been allowed to at least consider whether to keep the jury recommendation of life without parole or to give him a chance at parole. So I'll reserve the rest of my time.
All right, that would be 3 minutes and 13 seconds. Attorney Poprawski.
Yes, Your Honors. Good morning. Lindsay Poprawski on behalf of the state of Ohio. And the heart of Kirkland's appeal centers around his claim that the state pursued the death penalty through a supplemental indictment in retaliation for his initial decision to assert his speedy trial rights. In his brief, Kirkland has not raised this issue in the trial court. And in his brief, he conceded as much. To that end, Kirkland forfeited all but plain error for purposes of appellate review. And the state would submit that because this is on appeal under a plain error analysis, there are multiple reasons that the court should reject this assigned error. In a pretrial setting, a prosecutor is free to seek additional charges on whatever the evidence can support. And no presumption of vindictiveness will attach if the defendant was clearly subject to those charges at the outset. A prosecutor should simply be free to exercise discretion in bringing subsequent charges. An initial decision should not freeze future conduct. Because the incidents about which Kirkland complains occurred prior to trial and involved prosecutorial discretion in bringing subsequent charges, a presumption should not be invoked here. Rather, Kirkland must objectively prove his claim by making a showing of actual vindictiveness on the part of the state. And the state submits that Kirkland has failed in his burden. The only claim in support of prosecutorial vindictiveness is that the capital specification was brought at a point in time after Kirkland asserted his speedy trial rights initially. By failing to assert this claim in the trial court, this court is left with a limited record in which to piece together Kirkland's arguments. Kirkland's speedy trial rights were addressed on the record at an early pretrial in this case, which was in November of 2016. As Kirkland indicates, he had initially refused to waive them and the clock was set to run. The trial court confirmed that Kirkland was under a mistaken impression as to how the law applied to his speedy trial rights. After advising him correctly on the law, Kirkland ultimately agreed, after consulting with his counsel, to sign a partial time waiver until May of 2017. A firm trial date was agreed upon with counsel and Kirkland. That same day, those dates, Kirkland's partial time waiver and the trial court was entered into in an entry. The journal entry also stated that the trial date was continued at the request of the defendant. Nearly 2 months after Kirkland signed this time waiver, the supplemental indictment was filed against Kirkland to add the aggravated murder count with the capital specification. Kirkland's claim to prosecutorial vindictiveness is based solely on the timing of this supplemental indictment. And he claims that it was unreasonable and disproportionate response because he forced the prosecution into a speedy trial. However, this logic is flawed because Kirkland did not force a speedy trial on the state. Instead, he agreed to waive time at the November 21st, 2006 pretrial based on his own admitted misunderstanding of the speedy trial time and after being advised as such by the trial court and consulting with his own counsel. He never forced the prosecution into a trial, and he waived his speedy trial rights far before the state filed the supplemental indictment. Because the issue was not raised below, Kirkland's assertion is largely speculative. Kirkland also makes no claim that the supplemental indictment lacked evidentiary support for the specification. As indicated previously, in a pretrial setting, a prosecutor is free to seek additional charges on whatever the evidence can support. Here, Kit Kirkland was initially charged with aggravated murder, along with felony charges of aggravated burglary and aggravated robbery. And thus he could have been subject to the capital specification at the outset. The state remained free before trial to exercise the broad discretion entrusted to it to bring the capital specification. And Kirkland finally cannot establish any prejudicial effect with respect to the filing of the subsequent indictment. Kirkland was charged with aggravated murder by way of the initial indictment, which subjected him to a potential sentence of life without parole. Although the subsequent indictment added this capital specification, he ultimately did not receive the death penalty, but was sentenced to life without parole, a potential sentence from the outset. Ultimately, Kirkland's argument fails under a plain error analysis, and his first assignment of error should be overruled. Kirkland, in his oral argument, he just addressed the third assignment of error, which raised a constitutional issue. And the state would submit that there are several reasons that this court should not even address the merits of that constitutional issue. Basically, Kirkland is challenging the statutory sentencing structure in 2929.03, challenging that it unconstitutionally distinguishes between aggravated murder defendants for whom the jury recommends death and those for whom the jury has recommended a life option. And again, he concedes that he did not raise this issue in the trial court. And first, we start with the premise that constitutional errors cannot be raised for the first time on appeal. In his brief, he attempts to evade this rule by asserting plain error, by citing that plain error sentence, citing plain error in a single sentence, and incorporating plain error by referencing back to his first assignment of error. But this court should fail to develop a plain error argument on his behalf based on its traditional refusal to do so. In his reply brief, he cites back to the first assignment of error and argues that he properly preserved the argument for review. But again, this argument fails under App Rule 12A because assignments of error must be raised, arguments must be raised separately and argued separately. And this argument has not been preserved for appellate review. And if the court should reach this, the merits of this assigned error, the state would simply cite this court to the case law cited in its brief, State v. Malhado, which is a 10th district case that rejected a similar constitutional claim that Kirkland is setting forth, where it found that the statutory sentencing scheme set forth in the statute is constitutional as it's rationally related to a legitimate government interest. The state would ask this court to follow Malhado and likewise reject Kirkland's constitutional claim. Kirkland didn't touch on his second assignment of error, which challenges the manifest weight of the evidence here, but we would just note that that touches on the accomplice testimony and challenges the credibility of his two co-defendants, but we would note that that testimony is to be reviewed by the jury, and they are to test their credibility after being advised properly by the jury by the judge in jury instructions how to do so. And we would ask that the court reject that assignment of error as well and affirm the judgment of the court below.
Questions from Judge Hensel or Judge Sutton? No? Okay. Thank you.
Thank you.
3 minutes and 13 seconds for a rebuttal.
Thank you. When it comes to the issue of prejudice, yeah, Mr. Kirkland was greatly prejudiced by the fact that this was a death penalty proceeding, because ultimately, like I said, at the end, the sentencing got tilted in the direction to where he got a life without parole, whereas had the death spec not been added, the life without parole would have been a maximum consideration by the judge after the judge were to consider the statutory factors, and among, options of 20, 25, or 30 to life. And also too, as much as the state has the discretion to add charges or supplement an indictment, this was not a new charge, and this was simply, refiling the same charge, but then just upping the penalty. And like I said, and I think there is the distinction in the case law about that. And it's one thing if the state has new evidence and they add on new charges, but or let's say a victim is survived initially, but then the victim later dies, and then the state can add a murder charge at that point. That's not what happened here. The state waited over 2 months to even return the first indictment. And then when they weren't happy with Kirkland trying to force a trial, when nobody was ready for it yet, next thing you know, the death penalty is added. Oh, golly gee. So, and then that totally changed everything. And now,
counsel,
yes.
Counsel, excuse me. Are you making a structural error argument?
Yes, and that is laid out in the brief.
Do you agree that the plain error standard would still apply to that structural error argument?
Yes, and I think both apply. Ultimately, I think the structural error argument, it goes further to overcome any lack of objection that was, that wasn't made at the trial court level on that issue. And because the structural error it gets more to the fundamental framework of the proceedings. And like I said, when the death penalty is involved, like I said, changes everything in the proceedings, with how the trial conducted, with voir dire, the type of jury you get, and also what the judge what the judge can or cannot do. And that leads to the third assignment of error where, with the judge's hands being tied, that there's no rational basis as to why the statute can allow the judge to the discretion to lower the penalty if the jury returns the ultimate penalty, which is death, versus if the jury returns something less, then, oh no, he can't change that. So almost to create a situation where a defendant would maybe hope that he gets the death penalty so he can try to persuade the judge to give him a chance of a parole someday. I mean, that's crazy, and that's totally irrational. And there's no reason for why the General Assembly to say, oh, judge, you can, we'll give you discretion over here, but not over there. And there's no rational basis for that. And that's why the statute should be struck down. And I know that the 10th district has previously touched on that issue, but that was 19 years ago. And I think our understanding of the criminal justice system and it has changed a lot, and given the societal effects of criminal justice policies that have taken place for the past several decades has changed a lot since 2003. And I think, the Constitution is always a living, breathing document, and it should always be adaptable to society's, modern understandings of people and the way we, all relate to one another. So I think that the court should take a fresh look at that and not just, rubber stamp whatever the 10th district did. So, and I think the court should conduct its own analysis.
Counsel, with that, your time is up. I let you go over to answer Judge Sutton's question, but we want to thank both of you for your presentations here today. The court will take the matter under advisement, issue a decision in due course, and of course, you will each receive a copy of each be mailed a copy, I should say, of the decision on the day it's released. Our opinions are also posted on the Supreme Court of Ohio's website. We wish you a good day. And again, on behalf of Judge Hensel, Judge Sutton, we thank you for making this video appearance.
Thank you.
Have a good day.